Well, Mr. Medvedev is back. He's our Russian-born sovereign citizen, and he's getting his day in court, his trial. He has a very simple case. He was cited for tinted windows and no backup lights. But Mr. Medvedev has been indoctrinated by Marc Stevens, and he's going to try to complicate this simple traffic infractions into a federal case. I think you'll enjoy the interaction and the points that he brings up. He tries to follow the script. You'll probably be very familiar with all these tactics. So sit back, relax, and enjoy.
Sarcasm, you will be Artem Medvedev.
You, Mr. Medvedev?
I'm here on that matter.
Well, either you're his representative or you're himself.
I'm Artem Medvedev. I'm here on the matter on my special appearance.
Okay. This is a trial. There are two tickets, both equipment violations. Ticket ending 266 is allegedly a violation of section 375.34 of the motor vehicle law, and the other ticket ending 292 is an equipment violation 375.12 AB2. Relates to front driver and passenger windows being allegedly tinted, and the first ticket for a rear reverse light out, and this all refers to 2007 Chrysler. Okay, we're going to have the officer testify. I might as well do this at the same time. Do each of you swear or affirm that what you're about to say in court is the truth?
I do.
Sir?
I don't swear.
I didn't ask you. I said you can affirm.
Affirm? Oh, yes, I'm sorry. Yes. Before we start, I'm not ready yet. I have a couple of issues here. And I was bringing these issues up before Judge Freya. And she still set the matter for trial. However, first of all, I didn't have any information about who was presenting this case. I had multiple people presenting all kinds of information about this case, besides Officer Danette, who is original witness in this case and complaint.
What is your motion?
Oh, I mean, I filed motions.
I read your motions. Apparently, Judge Freya's indication on June 4th was that the motion wasn't properly filed. The suspension date was June 11th, but she lifted the suspension as a courtesy and scheduled you to come in for a pretrial conference, which appeared.
I'm sorry.
May have taken place on June 17th. Were you here on that day?
Yes, sir, but I'm trying to get clarification on what you just said.
I'm just reading the judge's notes. 6/4/14 motion was not properly filed. Suspension date was going to be June 11th, but she lifted that as a courtesy and scheduled you for a pretrial conference on the 17th. It appears that on the 17th, you requested a trial.
No, I did not request a trial. Here's the issue. The issue is that I have responded on 2013, and it was November 6th, to these allegations. Now, it was ignored.
I'm sorry, in what way did you respond?
You should have
Your motion?
you should have a affidavit of status.
I know I have two copies of it.
Yes.
I've read it.
And it's stamped by the court on November 6, 2013. Then my second response was...
But I'm not sure what relief you seek as a result of that.
Or relief. Well, I was supposed to respond, so I made a response, and I don't know why and on whose authority my information was sent to the Department of Motor Vehicles. And then I had to make a second response again, now through motions and directly to the complainant. and filed with the court. And then now you're saying that Judge Freya said that it was not properly filed. So can I please get a clarification of what was not properly done with my motions, which is...
I have no indication. I can come up with a couple of reasons right off the bat. Number one is that it doesn't appear to have been served.
It's not served, I'm sorry, to who?
Certificate of service? I see that.
Okay.
No, take that back. Appears to have been served. It's not clear to me what your relief request is. Usually in a motion, you're asking for something. What are you asking for?
Well, I mean, it clearly says that.
Statements.
Okay.
You say, as you said today, that you're looking special appearance and not court's jurisdiction. I got that. And then there's a lot of language about what courts can or cannot do. And then you make a conclusion statement that the plaintiff has failed to allege the required elements of the cause of action / crime, and the court has no jurisdiction. If that hasn't been ruled on thus far, I'll rule on it now. It's denied.
You deny the motion
That's what it just said.
to strike and dismiss. I'm sorry, on the grounds of what?
On the grounds that you don't tell me why it should be.
Okay.
I mean, I don't see that there's any technical basis with respect to the complaint, which in this case are the tickets. Why it's not correct. I'll let you.
I mean, I requested, I made a second motion for discovery that was not even responded to me by anyone.
Okay.
Uh,
Generally, this is not something that's done in district court.
Well, but with all due respect, objection. This is a matter of jurisdiction in the first place. This is it says in my motion for discovery,
Right.
and my first.
Okay, here's what you're going to hear a lot of, the word objection. This guy's been taught by Marc Stevens that everything that comes out of the judge's mouth is a lie, and therefore you should object to everything, because he convinces them that it preserves the issue for appeal. It's really kind of dumb, but hang on, you're going to hear more of it.
Motion as well.
If you look at the tickets, and you look at the information you're requesting, it's pretty clear, it's clear enough to me, that you were in the state of New York when this occurred, that you were present in the city of White Plains when this allegedly occurred, that you're subject to the laws of the state of New York, particularly by your voluntary, it's been often said that
Objection, Judge. But
you can object, but it's often been said that with respect to driving, that you don't have a right to drive. It's a privilege to drive that's granted you by the state and by their issuance of licenses and registrations and things of that nature. So you subject yourself to the laws of the state of New York when you decide to drive.
objection.
The valid cause of action is listed on each of the tickets. The specific violation section is noted on each ticket. An explanation of it is noted on each ticket. So I'm not sure why you're saying that.
Objection. The burden of proof is not on you, Judge. It's on the prosecutor or the one who's bringing the complaint against me.
Forgive me, but I'm the one who decides your motion.
Yeah, you deciding my motion.
I'm deciding your motion.
That
I'm not finding you guilty. I'm deciding your motion.
yes, sir. But in my motion, it clearly states that I'm asking for evidence of jurisdiction.
Evidence of jurisdiction.
Bingo, there it is. Jurisdiction, evidence of jurisdiction. That's what he's looking for. He's going to be given and has been given evidence of jurisdiction, but he gets so wrapped up in his own mind and his paperwork, he doesn't recognize the evidence when it's given, which is typical of a Marc Stevens acolyte. Let's continue.
Applicability of code and laws, whatever you decided that you alleging me. Oh, I mean, sorry, Mr. Dennett, alleged me in violating, and that's the the main point I wanted to put everybody's attention
What
to.
is your basis for saying that the court lacks jurisdiction over traffic matters?
I haven't provided any evidence of this being applicable to me in the first place. I'm looking for facts, not hearsay.
Drive?
I'm sorry?
Do you drive?
Well, now you're making discovery questions.
Well, if you weren't driving, you're not guilty. That's for sure. If you do drive, you're subjecting your own self to the laws of the state of New York by going to motor vehicles and getting a license and registering the vehicle. It has license plates on it. You have subjected yourself to the traffic laws of the state of New York when you've done that.
Objection. That's not an evidence. I don't see
There's
any.
nothing for me that I said that you can object to. You can disagree with it, but you can't object to it.
Sir, again, with all the respect,
You are free to appeal my rulings.
I'm looking for facts. I'm not looking for hearsay, and I'm not looking on assumption, because assumption is not
What
evidence.
kind of facts are you looking for?
For facts, I listed everything in my motion. The facts of code and laws being applicable in the first place, and I mean that I really had a lot of time. I was waiting for a lot of time to get that factual
Are you
information.
really saying that you're not familiar with the vehicle and traffic laws of the state of New York, that they exist?
Objection. This is irrelevant.
It's completely relevant. You're charged under the vehicle and traffic law of the state of New York.
Sir, are you assuming the burden of proof on the behalf of the plaintiff?
As I told you, I'm making
Now, this is what Stevens has also taught them to say. It's when the judge makes a ruling, you're supposed to accuse him of taking up the burden of the prosecution. It makes no sense in the real world, but in the fantasy world of Marc Stevens' acolytes, it makes sense. Let's continue.
ruling. I'm not assuming any burden of proof. The burden of proof is on people to prove the alleged offenses, but you're asking me to prove that the court has jurisdiction in the first place.
No, sir. I'm not asking you to prove to me that
Let's move forward.
Sir, objection. Are you relying on any facts of evidence that the people provided you with, that
No,
it's applicable?
It's an accusatory instrument. The facts and proof come in a trial.
Are you saying that the accusatory instrument is a proof of jurisdiction?
I'm saying that the accusatory instruments meet with the Department of Motor Vehicles rules, and they meet with, as far as I can tell, proper notice to you of what the offenses are alleged to have been, where they occurred, who they occurred to, who was present when it occurred, what city it was in, what state it was in, what particular section of the vehicle and traffic law was allegedly offended, what time it occurred. Yes, I find these jurisdictionally correct.
Okay.
Okay, the judge just laid out the accusatory instrument, which is the traffic citation. And he laid out all the alleged facts that, of course, will be proven at trial, and all the alleged circumstances. And what that does is that establishes a prima facie case. And the judge looks at that prima facie evidence, assumes that it's true, takes it at the best light that it's true, and that now the Mr. Medvedev has the burden to prove it false, to rebut it. In other words, the prima facie evidence establishes a rebuttable presumption of jurisdiction and truth. It's a rebuttable presumption. In other words, Mr. Medvedev has to rebut it. Let's continue.
Can you show me any evidence of that?
I don't need to. I've made a ruling.
You made a ruling.
Yes.
You made a ruling, and you assumed the evidence on behalf of the plaintiff. Is that correct?
No, I'm not assuming anything. I'm saying that it's jurisdictionally proper. Now we can go on with the proof and evidence.
Am I entitled to see evidence before in any proceedings
Sure. Is there
against
any
me?
evidence Other than testimony?
I need it.
Pardon? Are there any photographs or videos?
Evidence of jurisdiction, which I
We're past that, sir. I'm not going to go over this again for the 5th time.
objection. Well, the issue is not going to go away. I'm going to bring it every step out of the way.
Sir,
There he goes. And believe me, he does. And the judge doesn't care for it. Stay tuned.
I'm going to tell you right now.
Yes.
If you tell me there's no evidence of jurisdiction again, I'm going to hold you in contempt of court. You've made your point 5 times. Don't waste everyone's time. You may appeal my ruling, but that's your option. But it's not proper to make the same legal motion 5 times in 10 minutes. I've heard you. I disagree with you. It's your right to make the motion. It's my job to make a ruling on the motion. I've made a ruling. Let's move forward.
The threat of contempt of the court is going to be ground for an appeal.
See, he's been taught that everything is grounds for appeal.
All I'm saying to you is don't repeat yourself. I've heard you 5 times on the same issue.
So I'm being alleged of something that there's no evidence of.
Well, how do you know that until we've had a trial?
Because this is not a trial evidence. Jurisdiction is not a trial issue. I can bring it any.
That's another thing Marc Stevens pounds into their head. To always say that jurisdiction is not a trial issue. Well, yes, you can challenge jurisdiction at any time. But once that challenge is made, you either have to bring forth evidence for it or it has to be handled at trial.
Anytime.
You've brought it 5 times today.
I brought it.
You brought it in your motion papers.
Yes, sir. I brought it. Yes, exactly. Way before today. Way before even my first appearance
Okay, so
in front of.
what do you expect would have happened with your claim? What?
My claim.
Yeah, your claim that the court doesn't have jurisdiction.
I'm not making any claims yet. I'm just.
That's another thing Stevens always tells them to say. Don't ever make a claim. Don't ever say you're making a claim. Just say you're, making or requesting clarifications, which in essence, of course, is asking a question.
Objecting.
Proof of jurisdiction.
Again, I'm not asking you for proof. I'm asking for what you rely on in making, on what evidence do you rely on in making that ruling?
What do you mean by evidence?
And he's given him that answer. He went through the whole list of things that's in the accusatory instrument, the traffic ticket, and that is prima facie evidence that establishes that rebuttable presumption.
I need factual evidence that of jurisdiction because this is an essential element of any allegation.
Okay, now we're past that. Now you've raised it for the 6th time. You want to go for 7?
Sir, I pretty much said everything about the jurisdictional issue.
So let's say something about something else then.
That's nothing really to say too much about because, the main reason why I was coerced into coming here today and, it's not resolved.
What do you mean coerced?
Well,
you responded to a summons.
Yeah, what would have happened if I didn't come here today?
The license probably would have been suspended.
And then what?
And it will be up to you whether to respond to that.
Okay, see? That's how I'm coerced.
Yeah, okay, enough. People ready to proceed?
Yes, sir.
People are required to provide some testimony and/or evidence. Do you need to refer the tickets?
Yes, sir.
All right, first put your name, number, etc. on the record.
Officer Robert Denay, shield number 11, ID number 1932, the White Plains Police Department. Patrol unit.
Okay. Do you recall this incident?
Yes, Your Honor.
Can you tell the court what happened?
Absolutely, Your Honor. Your Honor, on October 22nd, around 12:47 p.m., I was on patrol in front of the area of 244 Main Street, which is directly across from 275 Main Street, the Walmart, just to give a more
Can you run
perspective.
that by me again, please?
Sure.
You were at 244,
I was in front of 275 Main Street.
and that is Walmart?
That is Walmart, just to give you a reference. At that location, I was conducting traffic enforcement on the taxi lane,
Which is on the Walmart
which is on the
side.
Walmart side.
Right.
At which time I observed the defendant here operating a 2007 black Chrysler across the street, double parked, in front of 244 Main Street.
Where's that in relation to
That is
Five Guys?
the last store on the same side of Five Guys. I believe that's the Citibank there, just before the construction area.
Okay.
Yep.
So directly across from Walmart.
Directly across from Walmart.
And when you say double park, what do you mean?
He was double parked, blocking lane of traffic.
Okay.
I approached the driver, Mr. I'll try to pronounce the name.
Medvedev.
I'm sorry?
Medvedev.
Medvedev. I approached the driver's side window, at which time was rolled down, and Mr. Medvedev was operating the vehicle at the time. I advised him he was double parked and he needed to move his vehicle. Proceeded to ask me where he should go, that he was waiting for a client, which I would assume he was a livery cab or a taxi cab of some sort. He did in fact produce a hack license, I believe it's a Westchester County hack license. I advised him I can't give him that information, but where he was unsafe and he needed to move his vehicle. He continued to argue with me. I advised him if he failed to move his vehicle, I'd have to issue him a summons for being double parked. As I started to hold up traffic so he can back up because he was in the construction lane that was blocked off by cones, he proceeded to reverse his vehicle and roll up his window, which I could see that the reverse light was out and he also had tinted windows. He proceeded to pull into a parking space, which was not a parking space. It was actually bagged with a meter bag stating no parking.
Where was that?
That was just right in front of 244 Main Street,
Which
again was in
Citibank?
front of Citibank, correct. Again, once he was out of traffic safely, I approached the driver. He rolled down his window. I requested his driver's license and registration. He asked me what for. I advised him that his reverse light was out, as well as he had front driver and passenger side windows tinted, which were to the point that I could not see the driver on the other side of the windows. He produced them. Another officer appeared, Officer Park, as a secondary unit when I called out on the traffic stop. 2 summonses were issued to Mr. Medvedev, and the subject went on his way from there.
So do you have any questions relative to the testimony that you'd like to ask?
Yes, I would like to cross-examine the witness.
Point. Go right ahead.
Okay, here's where Mr. Medvedev gets his chance. And you're going to find this interesting. It'll be a little short intro here, and we'll pick it up in the next part, his total cross-examination.
Do you have personal knowledge of these facts?
Yes,
How so?
I just produced them to the court.
Just because you produced them to the court, you have a knowledge of them? Did anybody supply that information to you?
That's what he said, personal knowledge. As I take the testimony of Mr. Medvedev, I believe this officer was present and interacted with you.
Sir, I hold your respect, but you're not his attorney.
Look, you're treading thin ice right now, buddy. Don't tell me what to do in my own court.
I'm not telling you what to do. You're just leading him into answering the question.
I'm not leading him. I'm saying that I heard the testimony as meaning that he was physically present and had personal knowledge of the interaction with you. So you're wasting my time by asking what his basis was for making these statements. He was there. Okay, let's move on.
Objection. I'm not asking
I'm
you.
not asking you to object, sir. We went through that already, too. Now, if you want to conduct yourself as an attorney, then conduct yourself as an attorney. I'll be glad to hear relevant questions regarding the testimony. But if he said he was there and had personal knowledge, don't ask how. Continue.
Are you here today voluntarily?
Yes, sir.
Okay. So you stating you were not forced in here today. So nobody, no prosecutor, no judge forced you to come in here today.
No, sir.
Are you testifying because you want to testify today against me in these proceedings?
I'm testifying on behalf of that's part of my job.
Are you relying completely on your testimony to prove every element of the crime you charged me with?
I'm sorry, can you repeat that?
Are you completely relying on your testimony to prove every element of the crime you're charging me with? Are you competent and credible to prove beyond a reasonable doubt the code is applicable to me and I violated it?
You don't have to answer that.
Objection.
Credibility is my determination, not the officer's own determination of his own truthfulness. It's up to me to assess the credibility of witnesses.
I object to that. You have personal knowledge of the facts proving the laws and code are applicable to me?
Yes, the summons that was issued to you.
Were you coached and prepped in any way for your testimony today?
No.
So no one spoke to you before today about your testimony?
Correct.
Are you an honest man? Objection.
Again, it's up to me to determine the truth, the veracity of the witnesses.
Maybe you'd like to tell me the grounds on which you not letting him answer my questions.
First of all, it's irrelevant what he thinks of himself. We don't really even need to get into a philosophical discussion about it because it's not relevant.
So you're also prosecuting me with Mr. Dennett, right?
Move on, please, sir. Don't bait me.
Well, you're not being responsive to my questions too. Do you always tell the truth?
Yes.
Are you credible people should take your own words? I'm sorry. Are you credible people should take you at your word?
I'm sorry, say that again?
Are you credible people should take you at your word?
I would like to think so as a police officer.
So it's a yes or no?
That would have been yes.
Thank you. Do you always tell the truth to your supervisor at work?
Okay, enough of this. Move on to another area, please.
Sir, this is how I'm conducting my cross-examination.
And I'm cutting you off, that's correct.
On the grounds, please. Tell me the grounds, because I object.
It's not relevant to whether you were parking in reverse without a reverse light. It's not relevant to whether you had tinted windows. The officer's credibility, while credibility is always an issue, has been established by you in the preceding questions. And now you're asking, after you've already asked him whether he always tells the truth, now you're asking him, who does he tell the truth to in particular? When you ask the question, sir, do you always tell the truth? That would include always, and for all time and to everyone. So you've already essentially asked that question.
Objection. You're leading.
I'm talking to you.
Yeah, he gets pretty salty there with the judge. And we're going to end it here and pick it up in part 2. It gets really going real good. So I know you're going to enjoy it. Hope you've enjoyed this one. If you haven't, please like and subscribe. And stay tuned for part 2.